Upbeat, informative music starts and fades into the background. Are you an employer in California? Do you use any kind of software to help with hiring? If so, you need to stop what you're doing and listen up. A huge change is coming, and it could completely transform your recruitment process. Starting October 1st, 2025, California's Fair Employment and Housing Act, or FEHA, will have new rules for using artificial intelligence and automated systems in hiring. This is a game changer, and saying "I didn't know" won't protect you. So, what's the big deal? Here's the most important takeaway. If you use an AI tool to screen resumes, rank candidates, or even run targeted job ads, your company is fully responsible for any discriminatory outcomes. You can't blame the software. The law sees the AI's decision as your decision, period. This isn't just about fancy AI. We're talking about any automated decision system. That includes resume screening software, profile matching algorithms, automated tests, AI-powered video interviews, and even those chatbots that pre-screen applicants. If it uses code or rules to help you hire, these regulations probably apply. So, what do you need to do right now? Your first step is to take inventory. Make a complete list of every single automated tool you use in recruitment. Yes, even that simple resume parser counts. For each tool, you need to know who the vendor is, what data it uses, and how it makes decisions. This leads to your next step. Start asking your vendors some tough questions. Ask them for proof of anti-bias testing. Ask for the results of any disparate impact audits they've conducted. And critically, find out who is legally responsible if a discrimination claim is filed you or them. If a vendor is cagey or can't provide these details, that is a massive red flag. Once you have your list, it's time to classify your tools by risk. A tool that automatically rejects candidates is high risk. One that simply ranks them for a human to review is medium risk. And a tool that just organizes information is lower risk. Your high-risk tools need the most attention, the most documentation, and the most human oversight. Why does all this matter? The consequences for not complying are serious. We're talking about individual lawsuits, class action litigation, and investigations from the Civil Rights Department. This can lead to hefty damages, legal fees, and court orders forcing you to change your hiring practices. If you can't show that you did your due diligence, defending against a discrimination claim will be incredibly difficult. So let's recap your action plan. First, audit all your hiring technology. Second, engage your vendors and demand transparency. Third, assess and classify the risk level of each tool. Fourth, document everything, every decision, every test, every conversation. And finally, make sure you have strong human oversight protocols in place. A human should always be in the loop, especially for high-stakes decisions. California is leading the way on this, but other states are watching closely. The standards being set here will likely influence regulations across the country. Getting your house in order now isn't just about complying with California law. It's about future-proofing your hiring process. AI in hiring can be a powerful tool, but it's not a magic wand. These new regulations are a clear signal that employers can't outsource their responsibility to an algorithm. You must be committed to transparency, testing, and thoughtful human oversight. Navigating these new rules can be complex, so I strongly recommend consulting with an employment attorney who specializes in this area. An investment in compliance today can save you from major legal headaches tomorrow. Thanks for watching. If you found this video helpful, please give it a thumbs up, and don't forget to subscribe for more updates on a changing workplace. Stay informed and stay compliant.